Welcome everyone. Today's presentation will cover in great detail the process of reactivating a company that has been struck out or delisted from the Register of Companies by the Corporate Affairs Commission, known as the CAC. This issue affects many business owners and corporate practitioners, especially those who have not complied with filing obligations. Whether the strike-off was voluntary or automatic due to prolonged default, understanding the correct legal and administrative steps is critical. In this session, we will examine the meaning of a strike-off, its consequences, timelines for eligibility, required documentation, payment of fees and penalties, submission procedures, and potential legal redress through the courts. This presentation is designed to simplify the process for entrepreneurs, legal professionals, compliance officers, and company secretaries. Let's now move over to the slides for more interactive session. Okay, we will start by addressing the question before us that is on the screen. What does strike-off means? When a company is struck off, it is essentially deleted from the register of legal entities maintained by the CAC. This means the company is no longer recognized as a legal person. Its bank account may be frozen, assets can no longer be held in its name, and it cannot sue or be sued. There are two categories of strike-offs. The first is voluntary, where directors apply for removal due to inactivity or winding down. The second, on the other hand, is involuntary, often initiated by the CAC due to failure to file annual returns for 10 consecutive years or more. A struck-out company loses its legal capacity to do business, and its assets may legally revert to the state. Okay, now that we have known what a strike-off means, the next is for us to address another question: why reactivate a struck-out company? Reactivation allows a company to continue. Once restored, it regains all its corporate powers, such as the ability to operate a bank account, enter contracts, sue or be sued, and apply for permits or licenses. For companies with assets, reactivation is critical to recover and manage them lawfully. It also clears doubt in the minds of investors, creditors, and regulators alike. Importantly, for businesses that need tax clearance, government contract, or capital injection, legal status must be restored through the reactivation process before you can be able to achieve all that I have mentioned earlier. Okay, let's now take a look at the time limits and eligibility. There are statutory deadlines for applying to reactivate a company. For companies that were voluntarily struck out, you must apply within 2 years. If your company was struck off because of non-filing of annual returns for 10 years, then the law permits you to apply for reactivation within another 10 years window. Beyond this grace period, the only way to bring the company back to life is by securing a court order from the Federal High Court. This is why timely action is important. You must make sure that you apply within the statutory time that I have mentioned. If not, then you have to seek redress in the Federal High Court. As if you miss this timeline, you face a longer, more complex, and more expensive legal route through the Federal High Court. So you have to start on time. Then let's now take a look at the steps that you have to follow in order for you to get your company back to life. The first thing that you have to do is to verify strike-off status. The first step is to determine whether your company is actually struck off or just inactive. How can you do that? You do this by performing a public search using your RT number on the CAC website. You can also use the name of company, but most preferably for you to get the desired result, you have to use the RC number on the CAC website. If the name appears in the CAC's official strike-off publication, then the company has been formally removed from the register. It is important to obtain a copy of this publication as it forms part of your documentation when applying for reactivation. Also, check the exact date of strike-off, as this helps to determine whether you are still within the statutory reactivation period that I've mentioned earlier. For voluntary strike-off, it has to be within 2 years of the voluntary strike-off, and if it's non-payment of annual return for 10 years, it has to be within 10 years after the strike-off. Then the next step you have to take is after you have determined that your company was actually struck off, the next step is for you now to compile all the required documents that you need in order for you to make an application for your company to be brought back to life. That's the next step, is to gather all the required documents. Start with a resolution from the board of directors stating the company's intention to be restored. You will also need the company's incorporation documents, including the memorandum and articles of association. For each year the company failed to file annual returns, you have to file that. Then also you have to put together a statement of affairs, typically prepared by a chartered accountant. If the company is going concern or hard transaction, you have to provide an audited financial statement, and test clearance may also be required, which is not all the time. And also you have to ensure all annual returns are brought up to date. That's the fundamental thing here, because if it was struck off because you have not been filing annual returns, there is absolutely no way the company can be brought back to life without you updating your annual returns. So these are filed online and must reflect in the CAC's record before your application can proceed. So you have to make sure that the commission is seeing the application that you have made online, so that they can be able to work on it. Okay, the next thing is you have to now pay the applicable fees and penalties. To reactivate a struck off company, you must pay all outstanding fees. Each annual return costs the sum of 5,000 naira, and for each year of default, there is another additional 5,000 naira for late filing. That's the penalty. So for a company in default, for example, a company in default for 10 years, you are looking at the total sum, that's the official fee of 100,000 naira. That's if you are doing it yourself, you are not engaging a consultant in order to help you out. So in addition, there is an administrative restoration fee of 50,000 naira. That's for private companies, and for public companies, the cost is 100,000 naira. And for companies limited by guarantee, the administrative restoration fee is 50,000 naira. Very important, all payments must be made via the CAC payment platform, which is there is a gateway that will route you to the remitter platform where you will make the payment. And receipt must be kept safely as evidence, so that if there are any issues, you can be able to produce it and establish the fact that you have made the payment. Okay, the next is to file the application online. After you have made your payment, is to submit. After paying all applicable fees, you proceed to the CAC registration portal. You use the company's ROC number to log in. You under the order filing section, you have to now select application for administrative restoration or similar service. Then you upload all required documents, including the board resolution, the financials, and the statement of affairs. Then ensure the scanned documents are clear and properly labeled. Submissions are reviewed manually, so clarity and accuracy improve your chances of success. The approval officers will definitely have to see what you have filed. If it's not clear enough, your application will be queried and stalled. So it's very important that you upload very, very clear documents. Then the next will be for you now to monitor progress and respond to queries. After submission, you have to monitor your dashboard regularly. Very important, so that you know what's happening. The CAC may raise queries or request additional documentation, especially if there are discrepancies in dates, financials, or identity of the directors. If they don't tally with what they have in their records, there's always that tendency for them to call your attention, so that you can be able to rectify that. So, and also you must respond promptly to avoid the delays, so that your application will not be stalled. Once your application is approved, the company's status will be updated from struck off or inactive to being active. If you check the CSU website, you will see that if it's struck off or inactive, there will be a red indication below the company's name showing that, okay, this company has been struck off or inactive. On the other hand, once it becomes active, there will now the red mark will now turn to green to show that the company is now active. At this point, you can now proceed with business as usual, including reactivating your bank account, entering contracts with other investors, and most importantly, filing subsequent annual returns, because your neglect in filing your annual returns was the reason why it was struck off or inactive. So if you are diligent in filing your annual returns, your company will continue to be active, so that you can continue with your business with ease and without any distraction from the Corporate Affairs Commission. Then let's now take a look at when court order is required. If your company was struck out more than 10 years ago, or if you failed to act within the 2-year window for voluntary strike off, you must seek a court order to restore the company. And this involves filing and originating summons at the Federal High Court, and it has to be supported by an affidavit. And you also have to front load your statement of affairs, tax document, and proof of payment of your annual return. This is to establish to the court that you are now ready to be brought back to life. The company has complied with all necessary documentation that is required in order to bring it back to life. The court will review the merits of your application and issue an order directing the CAC to restore the company. Once you get this order, then you have to now file it with the CAC along with your reactivation document so that your company will be brought back to life. Okay, let's now take a look at the estimated timeline and the cost summary. The timeline for reactivation varies depending on the route. For straightforward administrative restoration, the process takes roughly between 2 to 3 weeks, within which you are through and your status of your company is back to being active. On the other hand, if a court order is required or needed, you may spend up to between 2 months, due to legal filings and hearings. Some of the bureaucracy that is inherent in our judicial system will affect you. And the cost varies for most small companies. Professional fees, penalties, and CAC charges the cost could go from, let's say, 250,000 to 400,000 naira. Depends on the years of annual returns that you have not filed. If legal proceedings are required, it may cost more significantly because you have to now retain the services of a legal practitioner that will have to stand for you at the Federal High Court. Okay, let's take a quick look at some professional tips and common pitfalls that you should look out for. Many reactivation applications fail due to simple errors such as wrong director details, inconsistent financials, or missing returns. You have to make sure that you file all the years, even if 1 year is missing. The CAC will call your attention to it so that you can be able to make the payment and rectify the query. You have to always ensure that your internal records match what is submitted, because CAC, they have your file already. So if you submit something that is different from what they have, your application will be queried. You react within the statutory period to avoid legal complications. Is very important, and always retain digital and physical copies of all documents submitted, so that once any issue comes up, you can be able to put together all your documents and make the necessary defense for your application to to be made active. Lastly, you have to engage qualified professionals who understand CAC processes. Their experience often makes the difference in successful reactivation. Most of the time, all the time, you don't know what it takes. So if you can be able to retain the services of a professional, you see that all the process will be complied with ease. Okay, to summarize, know your company's status. That's the very first thing that you have to do, because it's possible that your company is active and then you have the fear that it's been struck off or inactive. The first thing you have to know is that you have to know the status. Then second, you have to act promptly. Prepare accurate documents. Make sure all your documentations tally with what the commission has on their records. And very importantly, you have to pay all necessary fees. Use the CAC portal for submission. If you submit from any other portal, you are just wasting your time. You have to monitor feedback, very importantly, to exactly know where what is happening to your application, and respond quickly to requests or queries so that your application will move fast and succeed as you have planned. On the other hand, if a court order is needed, you have to consult a lawyer early to begin the process. Reactivation is not merely about regaining registration. It is about restoring your business's legal existence and protecting its assets and legacy, because the existence of your business is based on your ability to comply to your annual returns filing. So you have to make sure that you do this regularly to avoid any issues with the Corporate Affairs Commission. Okay, we have come to the end of this session. I will open the floor for you to ask a question, whether you are facing compliance delays, you need help preparing documents, or you have legal issues relating to reactivation. Now is the time for you to ask. I will be very happy to provide further guidance based on all that I have presented in this lecture. And for personalized consultations, further guidance and additional resources on how to reactivate a struck out company with the Corporate Affairs Commission, you can visit our website to access detailed guides, case studies, and expert insights designed to keep you informed of the latest regulatory updates and best practices. You can also partner with us to leverage our deep industry knowledge and take the next step towards how you can successfully reactivate your company that has been struck out of the Corporate Affairs Commission's record. Thank you for watching. Don't forget to download this presentation for your future reference, and you can subscribe to our YouTube channel for more valuable content such as this one. Thank you.